Welcome to the McNees Labor and Employment podcast series. This podcast will address medical marijuana in the workplace by Denise Elliott, attorney at law. Ms. Elliott practices in the Labor and Employment Group at McNees.
Since the passage of the Pennsylvania Medical Marijuana Act in April, the members of the McNees Labor and Employment Group have received many questions from our employer clients regarding the Act's impact on the workplace. The most common question has been, what do I do if I have an employee that is using medical marijuana? The answer will depend upon how you discover the use. So let's discuss two possible scenarios. The first would be the result of a positive drug test. The Act does not require employers to make accommodation for the use of medical marijuana on the property or premises of any place of employment. Further, the Act does not limit an employer's ability to discipline an employee for being under the influence of medical marijuana in the workplace or for working while under the influence of medical marijuana when the employee's conduct falls below the standard of care normally accepted for the position. Accordingly, for now, employers can continue to utilize and enforce their drug testing and drug-free workplace policies even when the drug being used is medical marijuana. With regard to drug testing, however, we ask that you stay tuned. The Act uses the key phrase, under the influence, but unfortunately, this phrase is not clearly defined by the Act. We hope that either the temporary regulations to be issued later this year or the permanent regulations will address this lack of definition and provide employers guidance on what is meant by under the influence with regard to medical marijuana. In the meantime, you may continue using and enforcing your drug testing policies as they currently exist. The second scenario would be where an employee voluntarily comes forward to disclose medicinal marijuana use prior to a drug test. There are a few things that employers should know and do when confronted with this situation. First, do not discriminate. The Act contains an anti-discrimination provision providing that no employer may discharge, threaten, refuse to hire, or otherwise discriminate or retaliate against any employee regarding an employee's compensation, terms, conditions, location, or employment privileges solely on the basis of the employee's status as an individual certified to use medical marijuana. The key language in the anti-discrimination provision is an individual who is certified. Only those certified under the Medical Marijuana Act are authorized to use medical marijuana in Pennsylvania and are thus protected by this anti-discrimination language. It will take some time for Pennsylvania to implement the regulatory framework to begin the certification process. Until then, any employee who reports that he is using medical marijuana is likely violating the law, as there's no mechanism for certification in Pennsylvania, and the Act does not appear to recognize certifications issued in other states. That being said, it is recommended that employers nonetheless be aware of the anti-discrimination provision of the Act and that care be taken not to discriminate against an employee on the basis of his or her voluntary disclosure of medicinal marijuana use. The second thing you need to do is analyze the employee's situation in accordance with the Americans with Disabilities Act. Under current law, the ADA does not prohibit an employer from discharging an employee who tests positive for marijuana, even if the marijuana was prescribed by a doctor. However, the employee who voluntarily and proactively discloses medical marijuana use due to a serious medical condition may be entitled to protection under the ADA. Accordingly, an employer should engage in the interactive process with such employee. And while we strongly recommend seeking guidance from counsel in these situations, there are some general steps to be followed. First, ask the employee in writing to obtain a letter or report from his or her healthcare provider. The report should identify the condition for which the marijuana has been prescribed, and it should tell how the use of the medical marijuana will impact the employee's ability to perform his or her job. Providing a copy of the employee's job description to the healthcare provider is a best practice. Second, if the employee's ability to perform the job is impacted, assess whether the employee can perform the essential functions of the job, either with or without reasonable accommodation. Remember, this is a fact-specific inquiry that should be conducted on a case-by-case basis. if you would normally provide medical leave to an employee who is temporarily prohibited from performing his job due to the use of a prescription drug, you may be required to do the same for an employee with a prescription for medical marijuana. Third, remind the employee that reporting to work under the influence and that the use of marijuana at work are strictly prohibited. And finally, continue communicating with your employee to fulfill your obligations to interact under the ADA. Keep in mind that this is an evolving law, and the interpretation and analysis may change rapidly. As the Pennsylvania Department of Health begins to implement temporary regulations, we will keep you apprised of further developments. In the meantime, if you have specific questions about the Medical Marijuana Act and its impact on your workplace, please don't hesitate to call me or any member of the McNees Labor and Employment Law Group for further guidance.